you ready to present your case?
Yes.
All right, come on up to the podium.
Thank you.
You have 15 minutes.
May it please the court, your honors, my name is Richard Gronsky. I'm an assistant prosecutor with Lorain County Prosecutor Dennis Wool's office. I represent the state of Ohio as the appellee on this appeal. Your honors, as stated in the appellee's brief, I believe this will be short and sweet in that the three arguments or propositions of error presented by the appellant in this case, he did not object to the magistrate's decision before the trial court or even after the trial court adopted the magistrate's recommendations, and therefore he waives under the civil rules, specifically Civil Rule 53D3 small b Roman numeral IV. He waives his right to present those arguments on appeal. I had never encountered that so far in my career, so I did file a motion to dismiss, which was overruled by this court, understandably, because I'm sure that the court can consider if there's any extraneous or exigent circumstances. There were not. As we look at what the magistrate's decision was, as reported on the last page, it specifically gives notice to all parties. This was Magistrate Falco on behalf of Judge Rothbury's court. Last page, under notice in bold, a party shall not assign an error on appeal to the court's adoption of any finding of fact or conclusion of law unless the party timely and specifically objects to that finding or conclusion as required by Civil Rule 53D3. This was not done, so basically the findings of fact, conclusions of law of the magistrate were adopted by the appellant in this case also. Therefore, just on that basis, I would ask that all three assignment of errors be overruled and that the judgment of the trial court be affirmed. This has also been found by this particular court as stated in page 6 of Appellee's brief, where failure to specifically raise an argument and an objection to a magistrate's decision results in forfeiture of that argument on appeal. Johns versus Johns, Coleman v. Coleman, 9th District Court of Appeals, and the sites are on page 6 of Appellee's brief. Regardless of that, I did respond on behalf of the state of Ohio regarding factual issues on the three assignments of error. The first one, Your Honors, is basically that the court properly found that this 2008 Mercedes-Benz was subject to forfeiture as both a proceed and as a mobile instrumentality, excuse me, allergies here this morning. As part of the criminal case, respondent Reginald Johnson forfeited his legal, equitable, and any other ownership interest he may have in the 2008 Mercedes that was seized from him. While it was titled to Northwest Auto's name, Johnson, by the facts presented to the trial court, used the vehicle with dealer plates, Northwest Auto's dealer plates on them, from at least August 1st through the seizure by police in Lorain in December of 2012. All that time, he had the Mercedes, there was proof of it, with the Northwest Auto plates on it. He was even issued a traffic ticket in the car in Cleveland, and there was circumstantial evidence that he drove the car to Georgia for a family reunion. At the time of seizure, his personal possessions were in the car, and he did hundreds of dollars, I believe a little over $600 worth of repairs that he paid for that Mercedes-Benz. The car was present at his home when it was seized and had been present when a drug deal went down at his home. So he had full use of this car, used it for his everyday business. He had no source of income, no legitimate source of income whatsoever. Yet the police found and testified to that he had hundreds, over $100,000 in real property that he purchased and made repairs to, along with having this Mercedes, cash, and the numerous drug deals that he had done. He was definitely a high mid-level drug dealer to low high-level drug dealer. He was charged with racketeering as well as numerous counts of drug trafficking. Based upon all that, the trial court correctly found that there was ample evidence that Johnson had the Mercedes as both proceeds and used it in his day-to-day business, whatever that was. Obviously, though, he was a drug trafficker with no other source of legitimate income, and the court found that it was both an instrumentality and a proceeds of his racketeering drug trafficking. Therefore, factually, assignment of error number 1 of appellant should be overruled and the trial court be affirmed. The second claim is that the trial court erred in not finding Nasser H. Nasser, the owner and basically sole proprietor of Northwest Auto, not finding him to be a good faith or innocent owner of this particular Mercedes. While the state did not investigate financially the $36,000 that was paid for by Northwest Auto for this Mercedes back approximately in June, it's interesting to note that Mr. Nasser paid off the lien on this vehicle sometime in September of 2012, all the time when respondent drug dealer Reginald Johnson had use and possession of this 2008 Mercedes. Mr. Nasser couldn't explain the chain of custody, and there was also evidence based upon a contempt sanction hearing for lack of discovery that was had before the court, where the state called Mr. Nasser to the stand, and of course his testimony during trial. Every time he testified or offered evidence, the story seemed to change. And he stated at first that when he purchased that vehicle from the auto auction, he heard a noise and immediately himself drove this vehicle to Odessa Auto Auction, a different auto auction, and parked it in the slot, never logged it in with the auto auction, etc. And that's the last time he saw this vehicle. That's the first testimony. That's under the sanction hearing testimony. During trial, he changed his story. I had the vehicle for several months. Well, where did you have it? When did you have it? Couldn't answer those questions at all. It was obvious based upon the testimony and evidence presented that Nasser was involved with drug dealers. The key here and the key nexus was that he was involved with not specifically Reginald Johnson, but with a drug dealer, convicted drug dealer named Kevin Armstrong. Kevin was the nexus between Northwest Auto and our respondent Reginald Johnson. They're both drug dealers, they knew each other. Reginald's truck was seen by Cleveland Heights narcotics surveillance at Kevin Armstrong's address. Kevin had also been surveilled by Cleveland Heights police in having other Mercedes-Benz, not specifically this one, but other ones with Northwest Auto dealer plates on during the same period of time. Kevin Armstrong also had purchased a 2006 Mercedes from Northwest Auto. Now that wasn't found out through any discovery because Mr. Nasser didn't provide that information when specifically requested. We found it through title searches to find out that this other convicted drug dealer actually had business dealings with Northwest Auto. That was also proven on the stand under cross-examination. I hate to say it, but every time Nasser opened his mouth, it seems like the new mistruth came out. And the trial court magistrate who heard both the sanction hearing and the actual hearing did make such a finding. It says you can't have clean hands when you're basically lying and changing your story to fit the factual pattern as presented by the state. Nasser's nephew, who was at Northwest Auto when Lorain police detectives went there to inquire about this vehicle that they seized, at first knew nothing about it, and this basically hearsay testimony was part of the sanction that came in as the settlement for the sanction hearing against Northwest Auto. He at first, the young Nasser, we don't know anything about this. And then, of course, as the detectives pressed more, the stories changed that, oh yeah, Reginald Johnson, he came in and took it for a test drive months ago and never brought this $30,000 to $50,000 car back. It's incredulous. the whole testimony is. But once again, when questioned, their stories change to try to fit the fact pattern of the state of Ohio. Since you have to have some clean hands as being a good faith owner, I believe the court's decision should be affirmed, finding that Nasser, the owner and sole proprietor of Northwest Auto, was not a good faith owner by the statute, and therefore his claim should fail for this seized, subject to forfeiture 2008 Mercedes-Benz. Lastly, they try to say that the court erred in allowing the Lorain police to state what Reginald Johnson, who was a party opponent, he was served, had filed an answer, etc., what Reginald Johnson said concerning Kevin Armstrong, in that Reginald was paying Kevin Armstrong for this Mercedes. Here's the nexus. Reginald to Kevin Armstrong to Northwest Auto. That's how the vehicle was being used and or purchased, all the while with Northwest Auto dealer plates on it.
Now, I was a little confused.
Yes.
Reginald Johnson, can you explain who he was again?
Reginald Johnson was a party opponent in this particular case.
But what was his how was he associated with these other people, I think?
With the other people, well, under the surveillance, we knew that he knew, the state knew that he knew Kevin Armstrong from Cleveland Heights, in that Reginald's truck, a Dodge, was located and surveilled. Detective Chris Skok, S-K-O-K, testified that they saw Reginald's truck, and they didn't know who Reginald Johnson was, saw it at Kevin Armstrong's property. Okay? Reginald also stated, both to LPD during questioning, that he was paying for a Mercedes, the Mercedes that was seized, to Kevin Armstrong. Kevin Armstrong's not listed as a title either, but the only thing that we know and we were able to prove, Kevin Armstrong had prior business dealings with Northwest Auto. We know that by number one, he bought a 2006 Mercedes from Northwest Auto, and number two, Cleveland Heights Police, in a whole separate investigation of Kevin Armstrong, observed him driving Mercedes-Benz vehicles that had different plates on them. They were dealer plates that came back to Northwest Auto. There's some type of connection between Kevin Armstrong and Northwest Auto. We obviously did go try to speak with him, but kind of loose lips sink ships. We did not get anywhere with Kevin Armstrong, even though we tried. The statement that Reginald Johnson said that I was paying my man, or Kevin Armstrong, for this Mercedes, came in because number one, he was a party opponent, number two, he wasn't present, and the court has wide discretion of leaving the evidence come in. They let that statement come in, and that also helped provide a nexus between Northwest Auto, Nasser, the owner and main proprietor of it, and then Kevin Armstrong, a convicted drug dealer out of Cleveland Heights, Cuyahoga County, and then our convicted racketeering drug dealer, Reginald Johnson. So, once again, because the appellant did not provide anything to the court saying why they objected or why they specifically thought that should stay out, under the civil rules, they adopted that and they waived their right at Court of Appeals to make that as an appellate argument. Based upon that, Your Honors, and I think the first one is the strongest, the three assignment of errors should be denied in this particular case, and the judgment of the trial court ordering the forfeiture of the 2008 Mercedes to the state of Ohio, finding that Reginald Johnson was a de facto owner and that Nasser was not a good faith lien holder or an innocent owner, should be affirmed by this appellate court.
Just as a question, was Johnson under surveillance to begin with, or was he sort of backed into because of?
No, Johnson was under surveillance by Lorain police,
Okay.
and it's interesting to me at least how we became aware of Cleveland Heights investigation. There's something called OLEG, which probably all have heard of on there. When you run a scan on OLED, it comes up who ran the scan, not only for Attorney General tracking purposes, but that. When Reginald's truck was found over in Kevin Armstrong's driveway, they ran that. They saw that Lorain police have run an OLED search on Reginald Johnson. So the Cleveland Heights Police contacted them and said, "You interested in him? What it gives?" That's when two departments started talking, and we began to learn an outside nexus. And that didn't even come into play, not really criminally. It came into play, Your Honors, with this particular C's 2008 Mercedes-Benz. Then all of a sudden, the light went off in my head. I said, wait a minute, there's a connection between these two. And then, of course, when we looked further, we found, and as part of the evidence that was presented in court, that Kevin Armstrong did buy a 2006 Mercedes, which, of course, was not divulged in the discovery process
And
for non-certain.
Counsel, you're out of time.
Thank you.
If you would wait one